Proceeding to the order of House bills on third reading, on page 29 of the calendar, under third reading, we have House Bill 1593, offered by Representative Barbara Hernandez. Mr. Clerk, read the bill.
House Bill 5093, a bill for an act concerning education. Third reading of this House bill.
Representative Hernandez is recognized.
Thank you, Mrs. Speaker. This bill will remove the condition that students who graduate from Illinois and Illinois high school must be an Illinois resident to be eligible for in-state tuition. This doesn't change anything else on the requirements for schools, for students. They still have to legally be able to graduate in Illinois. This just removes that condition.
Leader Windhorst, for what reason do you arise?
Thank you, Madam Speaker. Will the sponsor yield?
Sponsor indicates she will.
Thank you. I appreciate the description of the bill. Why is this bill being brought forward? Why is this change being made in the law?
This was an initiative from the Attorney General's office. They currently have a pending litigation, and they just want to make sure that this is not going to be a concern for students, that this is going to help the students in the area, in the state of Illinois, and also the universities.
And who is the litigation with?
I believe it is with the federal government.
And is that a lawsuit that was brought by the current administration based on in-state tuition being provided to those that are not legally in the country?
That is correct. However, this bill itself is not going to, will not assist in that litigation. It's just making sure that we're in parity with all the other states that are also removing this state condition.
So to make sure I understood correctly, this will not resolve the litigation, correct?
That is correct.
That will still be ongoing, but this is to bring us in compliance, or not in compliance, but
that's correct.
parity with other states.
That is correct.
And to do that, we are saying that for in-state tuition, a student, we're eliminating the requirement they attend a high school while residing in the state of Illinois and have not established residency outside of the state before enrolling in the university in several sections of our higher ed statutes. Is that accurate?
That is correct. A student must still have attended an Illinois high school for 2 years and have graduated from an Illinois high school or receives a GED in Illinois. So that is still the requirement there. We're just removing that residency requirement.
Toward the end of the bill, trying to find the exact citation. I believe it's in this, beginning on page 45. There's some new language regarding non-immigrant aliens. It says beginning on July 1st of this year, notwithstanding any other provision of the law to the contrary, for tuition purposes, a board shall deem an individual other than an individual who is a non-resident alien status that precludes an intent to permanently reside in the United States under subsection A of the applicable U.S. Code. We'll treat them as an Illinois resident until the individual establishes residence outside the state if certain conditions are met. It looks like there are 5 conditions that are included. What is the purpose of that new additional language? And that's from page 45 to 46.
Well, we are making this to be impacted for public universities and community colleges. So that's underneath where you're saying the 5 items will be under the community colleges. So if the student in universities, they when they attend, they currently required to be an Illinois resident. However, there might be a gap, especially if your community colleges are going, or a student is going to a community college and they're going to transfer to a university. In my case, I went from Waubonsee Community College to Aurora University. That is also making sure that they're both included in this.
And specifically, number 5 says, in the case of an individual who is not a citizen or a permanent resident of the United States, the individual provides the community college with an affidavit stating that the individual will file an application to become a permanent resident of the United States at the earliest opportunity the individual is eligible to do so. Is that in compliance with federal law, or is that language just specific to this bill?
I believe that might be federal law.
And the reason I ask, it seems like we should just limit it to U.S. citizens or permanent residents without having this affidavit of intent to apply. Is there a reason we're not just waiting until the person becomes a permanent resident?
Because as we've seen, it's harder to become a permanent resident, especially for those that are currently DACA recipients. There is no path at the moment from the federal government.
And to summarize some of the things we've said, this bill is in response to a lawsuit involving the federal government suing our state. And the Attorney General has requested this bill, but it does not resolve the litigation. Is that correct?
That is correct. It brings parity to other states that have done it. And it's not only Illinois, it's also other states that have been involved.
And do you have a list of those states?
We believe it might be California is one of them, and Minnesota.
Thank you.
The question is, shall House Bill 1593 pass? All in favor vote aye. All opposed vote nay. The voting is open. Have all voted who wish? Have all voted who wish? Have all voted who wish? Mr. Clerk, take the record. On this question, there are 71 voting in favor, 37 voting against, 0 voting present, and this bill, having received a constitutional majority, is hereby declared passed.